Item number 1, number 5125, sub B.
Representative Blaze Zurier.
Thank you, Mr. Speaker, members of the House. House Bill 5125, Substitute B, with the blessing of the bill sponsor, Representative Anastasia Williams, and the Majority Leader, is on the floor today and has been amended by the Senate to make a few changes to the bill that we passed overwhelmingly by a vote of 44 to 30 on March 7th. The changes emphasize what was already law, and I'd like to go through them briefly. First, we have a change as to patient medical records. Given the change that was made by the Senate, a physician would have to record in the patient's medical records the basis for the physician's medical judgment that termination was necessary to preserve the life or health of the patient. It must also comply with all other relevant requirements applicable to physicians under Section 23-3-17. That section of law is the fetal death legislation, which is already law. Secondly, again, reiterating current law, this section change would allow and reiterates that the Department of Health may deny or revoke any license to practice medicine or any other discipline for a licensee upon a finding by the board that the person is guilty of unprofessional conduct under Section 5-37.5-5.131. And that cross-reference, just so you know, is to Section D in our statute that permits and requires that no abortion may be committed after viability under Section D. And that is also in addition to the criminal penalty that we've already provided under the statute. Third, a change was made with respect to the felony assault statute. Now again, this just reiterates what's already law dealing with a felony assault and makes abundantly clear that any battery or assault that results in the termination of a pregnancy where the person making that assault or battery is someone other than the pregnant person and knows or has reason to know that the person upon whom the assault and battery is made is pregnant. This clarifies the law under our felony assault statute and also makes clear that this provision does not apply to any changes that we made under the Reproductive Privacy Act and any abortion performed under this act, and also any medical treatment that's provided for either the pregnant person or the fetus. And finally, this section of law removes a section that was important to many of us that brought Rhode Island back into the center with respect to parental consent. That section was removed by the Senate. It would have allowed minors to seek consent for an abortion from a grandparent or adult sibling over the age of 25, where the parents are dead or unavailable. That would have brought us in the middle of states across the country, but the Senate has removed that provision because they believe it's an expansion. Those are the only changes, and Mr. Speaker, this statute has been looked at, has been reviewed, has been argued, has been debated, and now it's time that we vote. So, Mr. Speaker, I move passage of H 5125, Substitute B.
Representative Blaze Zurier moves passage. That's seconded by Representative Handy, Representative Knight, Representative Messier, Representative Tabone, Representative Shanley, Representative Barros, Representative Alzate, Representative Casimiro, Representative Kazarian, Representative Tanzi, Chairman McNamara, Representative Kislak, Chairman Bennett, Whip Edwards, Representative Agello, Representative Walsh, Representative Fogarty, Representative Corfriend, Representative Canario, Representative Kazaa, Chairman Abney, Representative Donovan, Representative Ranglin, Representative Carson, Representative Ruggiero, Representative McEntee, Chairman Craven, Representative Caldwell, Representative McCannon, Representative Speakman, Representative Almeida, Chairwoman Williams. Representative Roberts.
I have an amendment, please.
Proceed.
I'd like to move LC 000-51845.
Representative Roberts moves amendment LLC 000-518/45. That is seconded by Representative Newberry, Leader Filippi, Representative Place, Representative Quattrochi, Representative Price, Representative Nardone, Whip Chippendale. Proceed.
Thank you. This amendment is simply to provide anesthesia to any fetus at 20 weeks gestation. This is simply just a humane bill, an act of compassion. And since Roe v. Wade was decided before current technology such as ultrasound and that sort of thing, I'm not sure whether the doctors really understood that babies were pain capable at that time. So now that doctors do understand that, we're just putting this in to try and prevent some of that pain. Now I know that in this, on this floor, in this body, we've passed lots of animal legislation to protect our furry friends, and many of you have even gotten awards for that, and I commend you all for that great work, because you did deserve those awards. But in the same way, I'm only asking you to extend that same privilege to these unborn, that's all, and try to prevent some of the pain that they experience during the abortion procedure. And critically, this amendment exempts anesthesia requirement where necessary to protect the health of the mother. So I'm hoping that you will vote yes on this. Thank you.
Representative McEntee.
Thank you, Mr. Speaker. I rise in strong opposition to this amendment. This amendment came before the Senate just hours ago and was defeated handily on a 12-26 vote. Here we are doing it all over again. This amendment is outrageous. First of all, it puts the fetus before the woman. A woman has to have the ability to get sound medical treatment. We should not be interfering with legislation that requires the doctor to anesthetize the fetus prior to performing a medically necessary abortion. Picture this. You are 20 weeks pregnant, or your spouse is 20 weeks pregnant, or your friend, and they have found that they have a medical issue that causes them to have to terminate that pregnancy. What a horrendous situation to be in the first place. It's heart-wrenching. And we're going to say, anesthetize the fetus at all costs. It sounds like a severe case of punishment for the woman for choosing to do so, for choosing her own health over the health of the fetus inside her. We are not vessels to carry fetuses around. We are people who deserve all the rights of every individual in this country. I can't say enough about how offended I am on this amendment. Doctors have to be free to perform medical treatment that they believe is in the best interest of their patient. And to anesthetize the fetus, especially in the case where the woman should not be anesthetized for medical reasons, will only hurt the woman's health further. And if anyone needs to be anesthetized, it should be the woman in an instance like this, and therefore the fetus would also be anesthetized. I can't see any reason for this language. I urge you all to vote against it. It is our life as a woman. It is our health as women, and it is our choice. Do not take this away from us. I strongly urge all the members of this House to vote this amendment down. It's archaic, and it hurts the woman. There is no sound medical treatment that can anesthetize a fetus in the first place. I mean, this takes us back, and it leads to infringing upon the woman.
Representative. Take another 20 seconds, but you've reached your time.
Speaker, I will close on that, but it is our body, our choice. leave government out of the decisions of a doctor presiding over a woman's health.
Leader Filippi.
Thank you, Mr. Speaker, and thank you, Representative McEntee, for your passion on this issue. I just think it's important that we all read the amendment and look to the last sentence that says, being anesthetized is necessary, shall be done unless a physician determines that it is medically necessary to preserve the health of the mother to not utilize anesthesia. So I understand your perspective, but many of the scenarios you just gave aren't applicable because there is this exemption. Thank you, Mr. Speaker.
Representative Blaze Zurier.
Thank you, Mr. Speaker, members of the House. I have read the amendment, and I want to point out a provision that Leader Filippi has not pointed out, and I think is a huge fundamental flaw in this amendment. Read the first clause. Anesthesia shall be utilized in any medical procedure to terminate an individual's pregnancy. Any medical procedure. So a medicinal abortion, anesthesia, doesn't matter whether you need it. Some other form of abortion, anesthesia, doesn't matter if you need it. You're giving it to people that may not even need anesthesia. And what is worse than mandating in this House, in this legislature, medical care for women in the community? I urge strongly the defeat of this amendment. Thank you, Mr. Speaker.
There are no... We are in session, folks. I know everyone's excited one way or another, but we're in session. Representative McLaughlin.
Mr. Speaker, members of the House, well, I would like to stand in, I will be supporting this amendment, and I'll tell you why. How about the baby? Okay? The baby that's going to feel all this pain and suffering. Did you forget them? I didn't. Thank you.
There are no other lights. Clerk, unlock the machine on the amendment. Please vote yes in favor, no opposed. Clerk, lock the machine. 24 in favor, 49 opposed. The amendment fails. Back on the act. Chairman Corvesi.
Thank you, Mr. Speaker. Before I begin my comments on this version of the New York-style unfettered abortion law now before us, I would like to take this opportunity to thank National Organization for Women President Tony Van Pelt for vindicating some of my comments made during the first floor vote debate on this bill. In an interview with Go Local News editor Kate Nagel on Thursday, June 6th of this year, Ms. Van Pelt stated in part, quote, "I think they will not overturn Rhode directly," unquote. This statement by the president of NOW mirrors exactly what I said during the first debate, that Roe versus Wade will never be overturned by the Supreme Court. Therefore, the unspoken implication for the immediate necessity of this bill's passage is a non sequitur. To be fair and balanced to Ms. Van Pelt, the remainder of her aforementioned quote was, quote, "but it will be made gutless," unquote. Once again, the president of NOW mirrors my comments made here during the initial debate. I stated while Roe versus Wade would not be overturned by the Supreme Court, reasonable limitations would be placed on the performance of abortions. Obviously, she feels these inevitable legal limitations would gut the ability of a woman to terminate with extreme prejudice the actual or potential innocent human life forming in her womb, while I believe these inevitable legal limitations would be a civilized society's attempt to save unborn children. Therefore, truth be told, the motivation for this bill by its national and local advocates is not a strict codification of Roe versus Wade, but an expansion of abortion rights in advance of an anticipated and inevitable civilized compromise ruling by a future rational Supreme Court. A correction factor. Regarding the substance of the bill before us, this bill has absolutely not been substantively changed from the unfettered abortion bill we sent to the Senate. This is the same bill that allows the qualified termination of actual or potential innocent human life at any point during the 9-month gestation period right up until birth. And I use the phrases actual or potential innocent human life because they are the only two options to describe the developing group of cells. For to deny either of these definitions is to be ignorant of biological fact. For these reasons, and so many more unstated, I respectfully request you vote against this bill. One final comment. I am not one given to optimism. It is not in my nature. However, if this bill passes and is signed into Rhode Island law, it does not become a federal law. Federal laws are beyond our reach. It does not become a Supreme Court ruling. Supreme Court rulings are beyond our reach. It becomes a Rhode Island state law, and all state laws are within our reach.
Chairwoman Williams.
I forgot I'm so nervous. And you know what happens when I get nervous?
I have never seen you nervous, Chairwoman Williams.
It is very hard for me to stand up and debate a matter with someone that I care and respect deeply. That is my colleague, Representative Corvese. But I, like him, I speak truth, whether you like it or not. That's in my DNA. New York style? Really? Non sequitur? Really? A rational Supreme Court? Honey, baby. Not yet. What I want to say to each and every one of you, from across the aisle, in this room, in our different communities, and in this state, I rise again on this piece of legislation to thank all sides on this issue, regardless of how right or wrong, salty or sweet, disrespectful or respectful, or misinformed, you all were heard. I want to thank Senator Lynch Prada and her team. I want to thank the House leadership, Representative Blajewski, Representative Alzate, Representative Shanley, Representative Barrows, and everyone in this chamber, regardless of what side you're on. I also want to thank those many that remained silent. Their thoughts of what if I, my daughter, my sister, found ourselves in a situation of having to make a choice. That thought was resounding. Ladies and gentlemen, it's more than a quarter of a century that women and men have been fighting this battle, this hard battle for a right to choose what is best for them. So I stand here proudly, with much confidence and respect to everyone, and say to everyone here, on behalf of every woman in the state of Rhode Island, and every girl, I move the passage of 5125, sub A, as amended, and I ask that you support this and give us the right to choose our own destination. Thank you.
Leader Filippi.
Thank you, Mr. Speaker. My understanding is this bill is here pursuant to 14G, where with the leader's permission and the permission of the sponsor, it was a House bill that was passed by the Senate and immediately transmitted here. I know it's properly before the body, Mr.
Yes.
Speaker. Under Rule 15D, we have a 3 p.m. cutoff for amendments, and this bill wasn't docketed on the House calendar until probably about 2 hours ago. So I think when we look at our rules next year, I think we do have to analyze our 3 p.m. cutoff for proposed amendments in light of 14G, which allows a bill to be immediately placed on the calendar. Because I do think we need to have the ability to put in amendments for bills when they are docketed on the House calendar.
You are correct, and if the bill was amended from how it was posted in the Senate, I would agree a little more with you. I mean, we could always look at our rules, and we do each and every year in session. However, this, we've sent notice that we were going to order it to the calendar yesterday morning, and it's essentially the same bill that was in the Senate at that time.
I understand, Speaker, and I appreciate the process we have for amending the rules, and I thank you for your time.
Thank you, Leader. Representative McCannon.
Thank you, Speaker. I stand in support of this bill. The issue that I've been hearing about is whether or not this is an expansion of Roe v. Wade. I have done my homework on this, and it is not an expansion of Roe v. Wade. Let's not forget what Roe v. Wade is. Roe v. Wade is a product of an American system whereby we have a Supreme Court that balances the rights of government versus the rights of individuals. We may not agree with every decision that the Supreme Court makes, but it's binding. And as Doc Corvese said, we don't have the ability to reach that. And America is not as much of a place as it is a concept. And the concept is that individuals have freedom. And it is through that use of the freedom that we have a better society. That's the point of America. That's what being an American is. The Supreme Court has spoken clearly on this issue. They spoke in the 70s. They've spoken thereafter on a number of occasions, including in the 90s. And they have decided that it is the woman's right to decide. And that's what's before us. This is not an expansion. This is simply codifying what already is the law. And I strongly urge all of us to do that. Thank you.
Representative McLaughlin.
Yes, Mr. Speaker, members of the House, I would just like to reiterate to you, okay, Roe versus Wade, which Representative McKernan, identified, that was 40-some-odd years ago. 40-some-odd years ago. DNA wasn't even imposed, okay? So every step of gestation, when I say every step of gestation from the fertilization process, okay? Just the fertilization process, a 3-week process, okay, produces a DNA, a living human being, of a human being. And it goes on. So if we go through the gestation process, which the Supreme Court could not deal with at that time because they didn't know when the viability of a child was. They couldn't define the viability. So there's been so many changes, so many scientific things that have made the change, you know? And I'm looking and I'm saying, nobody likes abortion. Nobody. You know? It's a taking of a human life. All right? But the Supreme Court to this date has not even recognized that. So, you know, with that said, I just trying to clarify my point. You know, I look and I say, modern medicine is unbelievable. They operate in a womb for spinal bifida. You know, I saw it with my own son. They pulled his heart out and switched it around. Okay? That was 33 years ago. And the procedure was called a switch procedure. Up until that point, they didn't know what anesthesia was for a baby. Okay? They just let him die. So, you know, with that said, I hope, you know, I plead with you people. The Supreme Court right now, Roe versus Wade is not under attack like some people think. Sure, a lot of people would like to change it, but it's not going to change. Okay? The statute remains the same. So what's the rush? Why not look at progress and see if there can't be a compromise that will bring everybody together, the mother and the baby, you know? So that's all I got to say.
There are no other lights. Clerk, unlock the machine. All in favor, please vote green. Those opposed, red. Clerk, lock the machine. 45 in favor, 29 opposed. The act prevails.